Within weeks of starting her medical malpractice lawsuit, I get a call from the defense attorney offering to settle this case. My client was suspicious. She was concerned. She was worried. Why are they offering to settle this case within weeks after having started her lawsuit? Was she right to be concerned? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. She brought a lawsuit because she claimed that her doctor was careless and caused her significant harm and injury. Now, we had the case reviewed by a medical expert who confirmed that we had a valid basis for a case, which then allowed us to proceed forward and start a case on her behalf. Within a few weeks, I get a call from the defense attorney telling me that he and his principals have reviewed the case and they would like to settle this case before it goes any further. Now, I take that offer and I go back to my client, and now we have a long discussion about it. The first concern she had was, why are they trying to settle this case so quickly? I thought you said these cases take anywhere from 2 to 3 years to resolve. And my response to that was, that's true. It does take normally 2 to 3 years in New York to resolve a medical malpractice case. And that is typically because there's no settlement offer that comes up until the time that we get to trial. And many times it doesn't even happen then. So why was she so concerned about the fact that now we had a settlement offer within only a few weeks? The interesting thing is that the defense clearly recognized they had a problem. And that was good for us. They recognized that they had a liability problem, meaning that it was going to be very difficult, if not impossible, to defend the case to show that their doctor was not careless. Okay, so once we get past that point, recognizing that the defense understands that it's going to be difficult for them to defend the case, now the case has to shift to damages. What is the value? What's the real value of these injuries? What permanent long-term injury or disability will my client have? What limitations will she have as a result of this wrongdoing? And now we have to come to a decision about what the real value of her injuries are now as compared to what they will be in 2 or 3 years. Because remember, ongoing care and treatment is significant when we evaluate damages. If her injuries are finished and completed and she's had treatment to take care of the problem that she did have, now her injuries are limited in some fashion. And there may not be any long-term permanent disability. There may not be any long-term loss of income. And so we have to evaluate that. If, however, there is the potential or the need for ongoing care and treatment into the foreseeable future, now we have to delve deeper and look at exactly what problems we can expect her to have based upon her current treating doctors, based upon our medical experts' opinions. And then we have to assess, okay, if she has these ongoing disabilities, these ongoing injuries, she's going to need additional surgery and physical therapy and rehabilitation, and she'll be out of work and out of commission for all of these months following that. We have to take that into account. So then once we analyze that, then we go back to the offer. And now we have to have a discussion about the actual offer. Is what they are offering a good number? Is it a fair number? Is it appropriate? Is it simply a first offer that they're going to try and lowball us to try and get negotiations going? Or is this what they really think your case is worth? And then we have to analyze it. If it's a lowball offer, then it becomes very simple. We can tell them, no thank you, that's not sufficient at this time. Then the question becomes, okay, are we going to have a counter offer? Are we going to suggest to them at this early stage what we feel your injuries are truly worth? The issue is, where is the defense going with the case? What feedback can we get from the defense attorney to get some feedback about where they think this case is going? What do they think the value of this case is? And many times when an offer comes very early, the first concern that I have is, okay, they must be looking for a significant discount to try and settle this case so early. This way they avoid expenses for the defense counsel. This way they avoid all the protracted litigation and the delays associated with that. This way they try and cut things off. They know that sometimes a guaranteed amount of money now is better than the uncertainty of going through the litigation process, as well as the uncertainty of going to trial 2 or 3 years down the road. So it's a calculated decision, and oftentimes a business decision, a calculated business strategy about whether or not to make such an offer. And if they do, then the question becomes, okay, is this your final number? Is this the number that's going to settle it, or do you have some room to negotiate? And once we come to a decision about where we think they are going, after knowing from the defense whether or not this is simply an initial offer, or whether or not this is something that it's just starting negotiations, then we have a better sense of what we want to do and where we want to be. If the initial offer turns out to be something that is absolutely outrageous and offensive, then I'll come back and tell them, look, this is inappropriate. We think the case is worth 10 times that much. And unless you're trying to be serious, there's no point in having these early discussions. If, however, you think that there is room for negotiation, then let's continue talking. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in New York. I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.